Next case is Spitzer Automotive, Autoworld, LLC versus Fred Martin Motor Company. Each party will have 15 minutes to present their argument. Now, this case is a little unique. We have appeals and cross appeals, but in your initial time, across that place, you'll have that time to discuss your 15 minutes. You can take time for rebuttal. When it gets to you, you'll have your 15 minutes to discuss all the arguments that are made today. And then, however you want to write that up, appeal, cross appeal, that's all up to you. As for your initial rebuttal time, how much would you like to reserve?
3 minutes, Your Honor.
3 minutes, all right, very good. So but here, I'm not going to change the bottom clock, so when that first up top gets down to 3, that's when your time will be up, if you're looking at your clock over there. The arguments are being recorded. When you come to the podium, please first introduce yourself. Secondly, make sure you speak in a clear, loud voice so the recording can pick you up. If you would, please stay behind the podium so that the recording can also pick you up there. It gets a little confusing if people go wandering away from the podium, so we appreciate that. I don't think it'll matter in this case. I don't think there's anyone that this will apply to, but if you're referring to a child or a victim or someone, please refer by initials and not their full name. Here to read your brief, and I'm ready to proceed whenever you are.
Good morning, Your Honors. My name is Paul Flowers. I represent the defendant appellant, in this case, Fred Martin Ford. I think I've already reserved my 3 minutes. I'm joined by Larry Bach and Kendra Daffett, my co-counsel, and Adam Huff, the company president, is here. We are here this morning on a jury verdict of almost $6 million on a breach of contract and claim for a declaratory relief. Our position that we've maintained at several stages in the proceedings below is that this case never should have reached the jury. As a matter of law, it should have been dismissed or summary judgment should have been granted, given that this court's standard of review is de novo over these questions of law. The jury verdict arises from an agreement that was entered in 2007 between the parties, my client Fred Martin and then Spitzer Motors as well. The agreement was entered to facilitate Chrysler's Genesis plan, which envisioned taking the existing car dealerships in the Akron area selling Chrysler line vehicles, relocating them and consolidating them to maximize efficiency in Chrysler's view. There were 3 relocations required, and 2 of them went without a hitch. My client moved his Dodge dealership from Hartville up to Norton to his Fred Martin Superstore. Spitzer moved their East Market operations into Vernon Odom Boulevard. Nobody protested that, and everything went fine. The agreement provided that the operations at Vernon Odom Boulevard were only to last for a period not to exceed 18 months. At that point, the 3rd relocation was supposed to take place, which was Spitzer moving down to a new facility on Arlington Road in Greene, Ohio. That's where the problem started. Initially, in 2008, Alan Spitzer purchased the property, moved some dirt around, maybe bought some materials, but then stopped the construction because of the economic conditions at the time. Then in April of 2009, we get the Chrysler bankruptcy that nobody saw coming. In that bankruptcy, Chrysler terminated Spitzer's franchise through the Bankruptcy Act. That led to congressional action. Congress passes Section 747, which gives these dealers that have lost their franchises the ability to arbitrate. Spitzer does prevail in their arbitration, and in litigation that follows in federal court, the Fox Hills litigation, is established that Spitzer's old dealership is still gone, but they have the right to a new dealership under new reasonable terms imposed by Chrysler, just like any other dealership. At that point, the 2007 agreement, for all practical purposes, no longer functions. There's no more relocations.
Why doesn't it function? The parties are still the parties to the contract.
Correct. And Your Honor, as a practical reason, it doesn't matter anymore because all the parties agreed to, and there was not to protest relocations. So the protest procedure in Ohio works where when a manufacturer wants to put a new dealer in, establish a new dealer, or relocate a dealer into an existing dealer's 10-mile radius, that existing dealer has the right to protest that. And all the parties that agreed in the 2007 agreement was to waive their rights to protest relocations. You can't relocate a franchise that no longer exists, and that's what had happened to Spitzer in the bankruptcy. They were getting a new franchise. And so what happens is that Chrysler issues the notice to Fred Martin after the arbitration proceedings, saying that they're going to establish a new dealership at Vernon Odom Boulevard. Now that's a concern. Vernon Odom is less than 2 miles from the North Superstore, whereas Arlington Road Green is much farther off in a very different community. That was always the concern. So the problem is Fred Martin has 15 days to protest that. If they don't protest that, then they're living with this dealership there till the end of time. So they do that, and not only does Fred Martin protest that, but Falls Motor Vehicles protest that as well. They're within 10 miles of this Vernon Odom site. So we got these 2 protests going, both of which are consolidated. Nothing's still been done about Green. The parties then entered the stay agreement in January 2011. And this is not just Spitzer and not just Fred Martin, but Falls is in there, and Chrysler is a party to it as well. And what Spitzer gets is they get more time to build in Green. So they had a limited period which they were supposed to establish their dealership in Green. They get more time. What's conceded is then that if either the Falls or the Fred Martin protests are successful, Spitzer will not establish a new dealership in either location, either Vernon Odom or in Green. So they've got that. And as a practical purpose matter then, Spitzer cannot proceed with Green because they've agreed they won't if the protests are successful. First, federal litigation has to end, then the protests have to end. So there's really 2 reasons we've touched upon already out of 3 for why, as a matter of law, these claims just could not succeed. I mean, the first is just dealing with the simple fact that all that was agreed to was a waiver of the right to protest a relocation and not establishment. And the Dealer Act, 4517.50, very clearly treats those as separate terms, they're not synonymous. And in everyday English, they're not synonymous. A relocation is something moving from one location to another, relocation. Establishment is creating something new, something new out of nothing. And the notice that Chrysler sends to Fred Martin uses the word establishment. We're establishing a new deal. That's what it says. They're not prohibited from protesting.
And does Fred Martin, when they file, say they're protesting a relocation or an establishment?
So they file for they protest the establishment. Now what a big fuss is being made about is in the second sentence of that, they use the word relocation. That's not really the protest. The protest is in the first paragraph, and they just track the language of Chrysler's notice. The second one just says, the grounds for this appeal, it's not really an appeal, are that Chrysler does not have good cause for the proposed relocation. Well, it still doesn't say Green. It doesn't even say Spitzer. It could be the relocation into Vernon Odom, could have been that, but it doesn't matter because this is jurisdictional. So that's what they're not talking about.
Isn't the contract generic? It says the purpose is to combine and relocate franchises. And then obviously nobody foresaw that there was going to be bankruptcy by Chrysler.
Correct.
But the intent of the contract is still there, and the parties involved in the contract are still the parties here today.
Correct. That's all true, but you hit on the right word, which is relocation. And that's used throughout that contract, not establishment, relocation.
So isn't that an issue of material fact of whether that was a relocation or establishment by the jury?
Well, no, it's undisputed fact. So remember, in this case, there's no dispute what happened. It's historical. It's established in the records. And so there was never a relocation agreement that Fred Martin would not be allowed to protest. There was, according to Chrysler notice, an establishment. Absolutely. And there's no factual dispute there. Like the vast majority of contract claims, this should have been resolved in summary judgment. One way or the other. The language is clear and unambiguous, the facts are undisputed. There's no reason for a jury trial in this case. And what's a jury going to do with that anyway? They're not trained to interpret contracts. What's important is that it is a jurisdictional matter because we're talking about administrative jurisdiction. All the board has authority over is the notice that is issued by the manufacturer and the protest of that notice. That's the Jack Mattia case and also Nissan North Olmsted. They say it very clearly. It doesn't go beyond that. So this whole idea of, oh, well, when you protest at Vernon Odom, everything stops. That's not true. The statute only says the manufacturer can't proceed with that location, which is Vernon Odom. Green was always outside of this until we get the stay agreement, which everyone voluntarily enters. So that's why this just logically doesn't work. It's like a bad puzzle where you spend a lot of time putting the puzzle together and then realize pieces are missing at the end. And the big piece missing here is what stopped them from going forward with Green, because it wasn't a protest. It couldn't, not jurisdictional.
Well, the state agreement involved Green.
Excuse me?
The state agreement involved.
Correct, Your Honor, but that's what was bargained for. That's sophisticated parties bargaining together. The breach of contract claim wasn't based on that. The breach of contract claim was based on the 2007 agreement. That's where you have to look, where's the breach? And there is no breach, because that protest, no matter what Adam Huff said in the witness stand, no matter what surplusage is in this notice, jurisdictionally, that protest could not exceed beyond Vernon Odom Boulevard.
But if the question of fact is about relocation or establishment, and then there's a provision in your contract that says you aren't able to protest the Odom, wouldn't that be a question of fact of whether that's a breach?
Well, yeah, but it's the first part of that. I don't see how there's any possible dispute over establishment or relocation. And they are two different things, both as the statute uses them, the Dealer Act, and in everyday language. I mean, if I relocate, I'm going somewhere else. If I establish something, I'm creating something new. They're two different things, and I don't recall any challenge to the definitional cases we cited in our brief on that. They're not synonymous. And here, what's important is even if there's some confusion in that, it's still a matter of jurisdiction, because that notice from Chrysler says establish a new dealership. That's all that can be protested, no matter what anybody intended. So to put differently, the Dealer Act does not allow dealers to just protest whoever they want to and stop all their operations. It's limited, and that's the point of Jack Mattia and Nissan North Olmsted. No. You're stuck with what the notice was. That's all you can protest. That's all that the board has jurisdiction over. So, yeah, this thing never had anything to do with Green in the first place. So, all their lost profits from that dealership, that's not our fault. A lot of other reasons why they weren't able to open Green. The bankruptcy, the arbitration, and so forth. All that, maybe economic conditions, but you can't pin that on us. And the
You're down to less than a little more than a minute in your initial time.
Okay, thank you. Yeah, I just wanted to get in there that, even if all that's true, you got this dispute over relocation and all that, even if all that's true, you got the Falls protest. I mean, Falls protested this too. They didn't sue Falls, they just sued us. And if everything stops once you have a protest of Vernon Odom, it should have been the same result in Falls protest of Vernon Odom. And while they say it's untimely and whatnot, the board accepted it, the board kept it on the docket for 12 years, and then ultimately the board dismissed it, not as untimely, but as moot, because they had sold the Vernon Odom property.
Counsel, let me ask you too, before you have to get into your rebuttal time, save your rebuttal time. In your brief, you cite the Bliss case from the Ohio Supreme Court that denials of summary judgment can be appealed. And you're talking only, obviously, on issues of law, though, right?
Correct. Well, yeah, and I know there's that mootness, but I don't see anything that really changed at trial. I mean, it was a very, very different event, but the evidence was still the same. The circumstances were still the same, and the unambiguous contract was still the same. Thank you.
Good morning, Your Honors. May it please the court and counsel. My name is Erin Poplar. I represent Spitzer Autoworld Akron in this appeal, and I was also counsel at trial. Over 15 years ago, two businessmen, Alan Spitzer and Adam Huff, entered into a deal with the help of Chrysler. Mr. Spitzer and Mr. Huff, both auto dealership owners, agreed to move their franchises to share the Akron-Canton market for the sale of Chrysler, Jeep, Dodge, and later Ram vehicles. Now, because of Ohio dealer laws, the only way that the franchises could be moved would be if Mr. Spitzer and Mr. Huff came to an agreement, which they did, and they signed a short 2-page contract. Through that contract, both of them agreed to refrain from filing a protest in the Ohio Motor Vehicle Dealers Board regarding the franchise moves of one another. And the language,
You're saying moves, but you specifically talk about relocation, right?
Your Honor, yes, the contract does use that word, but there was testimony at trial from Mr. Spitzer that the intent of the word relocation was to, it had no intent other than to refer to the moves as they were described in the contract. And we are talking about the intent of the parties here. There was no.
If you would determine there's ambiguity.
Correct.
Where's the ambiguity in that?
Well, the ambiguity comes in where Fred Martin is asking for you to construe the protest provision as saying that the protest waiver only lasted for 18 months. However, the protest or the contract language says that the waiver is that each party, and this is reciprocal, irrevocably waive, relinquish, and surrender forever their rights to protest. So I know that Fred Martin's side claims that, well, I only agreed not to protest for 18 months, but that doesn't square with an infinite protest as far as the language is concerned in the contract.
Well, how do you get around where it says relocate its Chrysler Jeep franchise to this location of its Dodge franchise in Akron, Ohio for a period not exceeding 18 months?
How do we get around that?
How is that an issue of material fact? How is that not potentially a breach there that would allow a breach back to the parties?
Your Honor, as is argued in the appellant's brief, they do claim that was a breach. They claim that it was a breach for Spitzer. Actually, in their brief, they claim it was a breach for Spitzer to receive a notice from a third party that said that the dealership would be reestablished on Viotum. Now, they don't have any evidence that, and no evidence exists, it's undisputed that Spitzer never breached the 18-month term. They were never there for any longer. So they're claiming in their brief.
But the contract was 2007 and the lawsuit was 2010, so that's past 18 months.
And the protest was 2000.
I mean, the protest, excuse me, the lawsuit.
Yes. Yes, Your Honor, it was. However, they argued that that was a breach of contract in the trial court in front of the jury. Now, the trial court could have found that there was no breach. We didn't operate there for more than 18 months. And there was no breach. The jury could have also found that there was no substantial breach. And that is defined as a breach that does not go to an essential element, an element that is essential to the purpose of the contract. The jury could also have found, well,
So you're saying time, they might determine that time's not of the essence on that particular.
and the contract does not say that time is of the essence. There is no time of the essence clause in this contract. Now, Spitzer didn't protest. Spitzer paid $200,000 to Fred Martin. That was a part of the consideration of the contract. Fred Martin also got almost $1.3 million from Chrysler in order to, as an incentive. In exchange for that, Fred Martin had only to refrain from protesting. And that protest is forever. It is not 18 months as they suggest, it's forever. But therein lies a major factual issue here. We needed a jury to come in and tell us how to square those two provisions. One that says 18 months, you can operate at verbatim for 18 months, but then one that says that you waive your rights to protest to the proposed relocation forever. And he did the one thing that constituted his consideration under the contract. And, you know, they could have potentially waited. They could have waited to see if Spitzer actually operated. But then they wouldn't have the right to protest. They would have the right to file an injunction. They would have the right to file a lawsuit. However, that never happened. And that leads me to one of the primary issues and problems with their arguments. And that is, it is undisputed, as I said, that Spitzer has ever breached the 18-month provision. Now, they're arguing that, essentially, that Spitzer repudiated the contract, that this was an anticipatory repudiation. They did assert that defense in their answer, but they didn't argue that at trial. They didn't present evidence specifically related to that, and they waived it. And I would point out that at trial, they really didn't, they weren't really making the claim that the repudiation was a breach. They argued that, but, or they presented some evidence on that, but they really didn't argue that. What their breach argument was at trial was that Spitzer was required to build a dealership in Greeley within 18 months. And they brought in extraneous evidence to try to prove that. They brought in a term sales and service agreement between Chrysler and Spitzer to show that they could only sell new cars for 18 months. They brought in extraneous evidence in order to try to prove that theory. And obviously the jury didn't accept the theory.
Counsel, with the 18 months, you're saying that that is critical, that it wasn't not in the contract for a consecutive period.
I don't think that's critical in the least. I think that the jury made specific findings in this case. It made 4 findings by interrogatory responses. And the second one, the jury found that Spitzer did not, or substantially complied with the contract. The jury could have either found that Spitzer didn't breach the contract, or that Spitzer, or that the 18-month provision was breached, but it wasn't a term that was essential to the contract.
Well, I guess my point is, if we're looking at the summary judgment aspect of this and ambiguities and what the 18-month period provided for, your argument was that they were, that they'd never been in operation in Akron for 18 months.
Yes, they never were. They were in operation for approximately 16 months. Then Chrysler's bankruptcy occurred. Obviously, they couldn't sell Chrysler's cars when that happened. And then they were noticed after they went through the arbitration process. Then Fred Martin was noticed by Chrysler, giving the address at Akron. And
So your argument is they were able to tack on 2 more months.
we did make that argument at trial, Your Honor, but I don't think that it's critical for that to, I don't think that if you find that our construction of that term at trial was not in line with the arguments, I don't think it matters, because the jury could have found that we breached, but
I
it didn't matter.
understand your argument. I'm just trying to get past the summary judgment stage. That's what I'm trying to figure out, what your argument is in regard to that. Because one of their arguments, I think, is that this is not ambiguous whatsoever, that these issues should never even be presented to the jury. It should have been as a matter of law that this was 18 consecutive months, and
Well, we never operated for more than 16 months. There was a notice given, and they anticipated that we would operate again and reach that provision, but we never did.
But the contract says location, it doesn't say operation. So when we're talking about summary judgment, we're talking about the literal words of the contract here.
Okay, I'm not sure what your question is.
It says location, right? It doesn't say operation.
It says that they relocate their franchises to Vernon for a period not to exceed 18 months. Thereafter, they will move to Green. There's no time period where they have to move to Green. And I'm just trying to get what your argument is. So you're saying, regardless of whether it says 18 months or not, are you saying that it's not a material, the time wasn't a material term? I'm saying that we didn't breach the 18-month provision. They can't. We never breached. That is absolutely undisputed. And in fact, in the previous filing of the case, we moved for summary judgment because we never breached the 18-month provision, and the infinite protest waiver language is not ambiguous. That was our argument. But the court found that there were ambiguities in the contract that needed to be determined by a jury, and we accepted that. And the other ambiguity is the relocation argument, and that's kind of what Fred Martin has focused on in this argument. If you read the contract, and it's only 2 pages, but if you read the contract, there is absolutely nothing in that contract that would indicate that relocation has any kind of special meaning, any kind of definition. And in order for Fred Martin's attorneys to try to explain this, what relocation means to them, they have to go outside of the contract in order to do that. And Mr. Spitzer testified at trial that he believed that the word relocation didn't have any specific meaning other than referring to the moves as they're described in the contract. And Mr.
How
Huff
do
did
you
not.
reconcile that with the fact that here are two commercial entities? They're not, they're people that are dealing in the same business.
Yes.
So do you have to, if there's a term of art that's used when you have two people that are in the same line of business, why do you necessarily have to define it?
Your Honor, that is absolutely a question of fact. The jury instruction on the issue says, words that have acquired a particular meaning in the business in which the parties are engaged will normally be given that meaning. And Mr. Huff, he did, in support of his summary judgment, they used an affidavit from Mr. Huff where he said, I knew what the word relocation meant in the auto industry, and I intended it to have that meaning in this contract. But he never testified to any of that at trial. He didn't testify at all to what he thought that the word relocation meant. He didn't testify that it was a term of art in the industry. He didn't have anyone else come in and testify from the auto industry that it was a term of art and that's what they would think that this contract meant. There was just no testimony in that regard, and that's absolutely a question of fact. The jury instruction goes directly to that question. Now, I want to also touch on the Green argument. It's really undisputed that in the stay agreement, which was entered into in June of 2011, that the parties agreed that the protest would encompass both Green and Vernon Odom, and that the consolidated protest would be dispositive of all of the issues between the parties. And the stay agreement's even written to say 300 days after a successful resolution of the protest, Spitzer can number one, operate at V. Odom. So if they had such a problem with operation at V. Odom, that kind of cuts against it, that they're just willing to agree that we can operate there for another 300 days. And also it states how long Spitzer will have to complete construction. Now,
Counselor, you're down to a minute left in your time.
Thank you, Your Honor. Mr. Huff testified at his deposition that he was protesting Green, and he acknowledged that he testified at the arbitration hearing that had everything to do with Green. And Mr. Huff also claimed that he only found out that V. Odom had been sold in 2021. That was contrary to his deposition testimony, where he testified, number one, that he was protesting Green, number two, that he was protesting V. Odom. And that the Green issue is important because Fred Martin absolutely agreed that these protests encompass Green. This jurisdictional argument, this became an argument in 2021 when they decided that they wanted to try to get out of damages, and that was the best way to do it. Try to say, this never had anything to do with Green. We didn't have anything to do with Green. We couldn't pressure damages there. And that was the entire point of making this Green argument. As far as the Falls is concerned,
Your time is up.
Counsel, let me.
You certainly may inquire if you have one.
Thank you. I just have one question because you did file a cross appeal.
yes, I did.
Yeah, and obviously it's your choice whether to argue it or not, but I want to make sure I understand something. In regard to your cross appeal, are you saying that in order to win the cross appeal, we have to overrule RPM versus OB?
Well, Your Honor, I think that, all cases are different. I think that it's potentially distinguishable. And the issue that I would likely distinguish the case on is the fact that there was a...
Well, I can't allow you to have 4 more minutes. I'm just asking you a question.
sorry.
Do you think we have to overrule OB in order to?
I think that it's possible to distinguish this case because there was an exchange of money.
Thank
Thank you, Your Honor.
I had stopped your time at the floor, and you were responding to Judge Carr's question, so we're kind of equal for you. About 3 minutes left when you're ready to proceed.
Thank you, Your Honors. I'll be brief. I just thought I'd follow up with Judge Carr's question on relocation and the summary judgment motion. And everyone agrees on what that term means. It's both the legal term as used in RC 4517.50, and it's both the term we use in everyday speech. And you just heard this represented, but I just want to repeat it. It's in Spitzer's brief on page 21. Mr. Spitzer testified that the word relocation as used in the contract was intended to refer to the moves contemplated in the contract, and it did not have a special meaning beyond that. We could not agree more. It was referring to moves, one dealer going to another location. That wasn't going to happen anymore as a result of the Chrysler bankruptcy. That franchise was dead in bankruptcy. What Chrysler served a notice of was an establishment of a dealership, not a relocation. And that statute uses those terms separately, not interchangeably. And that notice was an establishment. And all we could jurisdictionally protest was the notice. And jurisdiction did not come up during trial. It was in our original motion to dismiss. It was almost the very first argument raised, that all you can protest under that statute is what the notice says. And the notice says establishing a new dealership in Vernon. So relocation becomes critically important. This case shouldn't have gone to a jury because that term's not subject to different interpretations. And in the summary judgment motion, that had been based upon an interrogatory response where they said they started selling cars at Vernon Odom in January of 2008. Now, it came to trial February 8th, 2008. Given the benefit of that, they should have been out by August 8th, 2008, and we could protest whatever we want to at Vernon Odom, which is very close to that Norton dealership. The idea that you have to have a specific date in order to have a temporal period of time is just completely foreign to contract law. This provision was for Spitzer's benefit. They could start whenever they wanted to at Vernon Odom, but after 18 months, they had to wrap it up and be down in green. That gave them flexibility instead of setting an absolute date, absolute beginning date, absolute ending date. And contracts routinely have these, where you have a set period of time. Mr. Spitzer says, oh no, I could kind of use it in and out as I wanted to, so forth and so on. That's periodic. That's not a period. And it just would completely upend contract law. We buy into this idea the trial judge had that, no, you can't have a period of time unless you have an ending date specified in the contract, because that isn't always possible. Here, it was very clear. The contract was specific. Dealt with relocations. We are agreeing we're not to protest a relocation agreement, and we never did protest a relocation agreement. We never violated the contract. And even beyond all that, I mean, even if you get beyond all that, and you still want to affirm the verdict, it's just impossible for them to have any damage when that false protest was still there. That stay agreement was still there. They couldn't build in green for reasons that had nothing to do with Fred Martin.
Thank you, Counsel. I see
Thank
your
you.
time is up. I thank both attorneys for their presentation today. We'll take the matter under advisement. We'll issue a decision in due course. That decision will be mailed to you by the clerk of courts, and also be released to the highest and free court. Again, thank you all.